Good afternoon, everyone.
Good afternoon.
Good day.
Good day. I got some emails of some persons either sick or unable to make class tonight. So I'm not sure how many we're gonna have on, but I guess they'll listen to the recording. Did everyone get my last email? Say yes.
Yes,
Yes. Do you have a chance to read it?
you didn't say yes. No.
Okay, while you wait a couple more minutes to see who else will join, because we're doing chapter 6 tonight. When we do chapter 6, I am not going to go through the last 2 or 3 pages, which is from the Home Protection Act, because we've gone through that. That's will be like the 3rd time we're going through the same thing. The only difference is they're just pulling it out, saying what refers actually to the bank itself or to the insurance company, whoever approved the mortgage. So we'll focus on the main part, and then we have, how much that is? 3 cases to look at.
How many emails did you send, Ms. Arthur?
Only one last night.
Okay.
And then Monday I'd sent one with 3 cases. So the 2 we didn't do, which was Finco and Teresita Johnson and Scotiabank and the Gibsons, we'll do tonight. And then we'll look at this, the one that I just sent last night. But you did have a chance to read Johnson and Gibson. Say yes. That means no too. I hope not. So should we wait 5 minutes or are you ready to start?
Maybe wait a few minutes.
Okay, all right. You'll have a chance to read it.
Yes, ma'am.
All right, let's wait a few minutes for them. We can start. Okay, we're ready?
Okay, I have one case.
Okay. You have one case, what you mean? One case down,
Red.
red? Okay, which one?
That's the Scotiabank one.
Okay, and the Gibson, okay.
Right.
Anybody read Johnson? Okay, if you're ready, let's start with your Scotiabank one.
Okay. What happened in the Scotiabank one? The Gibsons fell in arrest of their mortgage. Scotiabank initiated an action for vacant possession. The house was appraised for in excess of about 900,000. They accepted a sale considerably lower, about 500,000, I think it was. The court did order for vacant possession, but Scotiabank's attorney left out a portion of the order. And after Scotiabank sold the property for what they sold it for, and they applied those funds to the loan, they realized that there was still a shortfall. And they wanted to go behind the Gibsons to get them to service that shortfall. But their attorney had neglected to actually include that part of, in the originated summons, they would have asked for all cost and all interest and everything. But in the actual order, their attorney had neglected to put that part of the relief they sought in the order. So they tried to rely on the slip rule to correct that clerical error. And the court said, although they agreed that it was an error, the court looked at the delay that Scotiabank, the delay that had passed, and how long Scotiabank took to bring this matter before the court to get the error corrected. And they hadn't provided an explanation for the delay. And the court was of the view that Scotiabank had to be aware of the delay. Scotiabank had to have been aware of the error long before coming to the court. And that since about 5 years had passed and the Gibsons had already started to move on with their life and different obligations, the court did not exercise its discretion to correct the error.
Because the judge said that it is apparent that only after the sale of the property below its appraised value, and on recognizing that the sale price did not cover the totality of the defendant's debt, then Scotiabank sought to make this application.
Right.
So it shows you again a breakdown in internal controls. Who was managing this? Because the appraised value was 953,000. And it said, it should be noted that in August 2009, counsel for the plaintiffs had written a final demand letter to the Gibsons indicating the intention of Scotia to sell the property for $630,000. And the total amount outstanding, inclusive of interest and miscellaneous add-on expenses, was at the time $571,586.09. But they sold the house for $500,000. And they applied $413,000 to the defendant's mortgage. So if you look at that appraised value, or even the sale price, they should have gotten some funds back. The Scotiabank took too long. I don't understand, because after they would have applied the funds from the sale, because the sale could not have taken 5 years, they didn't realize that they had a loss. That doesn't sound right to me. Any comments? It just don't sound right after 5 years. Or were they saying to the officers, the credit officers, that they let the ball fall because they should have pursued the difference? And so they decided to go to attorneys to get it.
I think their attorney dropped the ball initially in drafting the order, and then the bank dropped the ball in pursuing the shortfall.
5 years? That's not drop the ball. That's a long time.
Yeah, that's a very long time.
Just think about it. If you sold a property, right? Then you had to book the proceeds from the sale. So at the end of the year, you would have had a loss. Where you coming from 5 years later? I don't get that one. And you see just how these small little things is costing the bank money and its reputation. Because just based on the cases that we've looked through from Unit 1 up to now, you've begun to get a feel for where the weaknesses are. And it really makes you begin to think you really need, one, to review your statements, as it says in the Homeowners Protection Act. And two, you have to make sure that you are actually being charged the right amount. And that the bank is doing not just what's in their best interest, but also yours.
To that last point, do you think that the bank really discharged its duty to make sure that they got the best price, considering they sold it for almost half of what it was appraised for?
Exactly. And when let's say they had the appraisal for 953. Remember the earlier one that we had where the tenants took the property.
That was a Gibson as well?
For a small amount of money.
Right.
And the court said what? With the appraised value, they went with not with the one that he had, but another company had, because the one that he had, the appraisal was deceased. So they couldn't verify where he got his figures from. So in this one, they had appraised it for $953,000. And so now they have a sale for almost $300,000 less. You don't think they should have gone up for another appraisal?
Yeah, but too, and that Ms. Archer, the house may have been on the market for a long time. I think the bank may have gotten desperate to get it off their hand.
I think too, when they prepare these documents for the court, I don't think they give them sufficient information. They just worrying about the numbers.
Right.
Not the circumstances around it.
They want to just retrieve their funds.
That's the funds. They're only interested in the funds. And that's it. And when we do the last case at the end of class, you will see why. They're only interested in the money because of their rights. That's all they're interested in. Who did the other one? Teresita.
I was reading that. That's a long one.
That is not long. The main issue of Teresita is that the bank, which was Finco, again having obtained an appraisal for the property at 105, sold it for 70,000. And then
Sorry,
they came back.
Teresita mixed up with the Junkanoo one.
No, Junkanoo is a hot one. We could do that one at the end.
Okay.
Junkanoo one is a hot one. So we know if you look at paragraph 11, that's the normal requirement that the bank has to present to the court. And remember the case that we did earlier, where it was a bank of the Bahamas that did not have all of this detail. And the court told them they have to go back and calculate what actually is the balance outstanding. So That's the requirement. But you could start from paragraph 18. She admitted that she stopped making payments from 2011. She's another one. They just stop paying these mortgages and then they want to turn around and go to the court. So this is in 2015, this happened. So look at paragraph 19. They're citing the case of Commonwealth Bank, Evans versus Commonwealth Bank. And it says, in First Caribbean International Bank, Bahamas, and Dr. Hiram Mitchell and Carla Lockhart, they quoted the case of Cookmere Brick versus Mutual Finance. And that's always have to do with sale of property and the appraisal. That's the leading case right there. And in that case, they said the mortgagee must make an informed judgment. And because judgment is required, there are no steps which the mortgagee must definitely take. Generally, it's for the mortgagee to decide on the manner of sale, if appropriate, after having sought expert advice. The property should be properly advertised, that is, advertised sufficiently, frequently, and sufficiently widespread to reach the appropriate pool of prospective purchasers. The mortgagee is entitled to decide the length of time the property should remain available for sale. Subject to this, the property must fairly and properly be exposed to prospective purchasers. The mortgagee is not under a duty to improve the property for sale. The mortgagee is not under duty to pursue or obtain a planning permission. And it seems to me, by parity of reasoning, the mortgagee is under a duty in a case such as this one to remove encumbrances like the grant from the property. But a mortgagee is under a duty to bring to the attention of prospective purchasers potential advantages that might be achievable. So that, for example, prospective purchasers ought to be informed of the property's development potential. Where the sale price is just above the sum required to discharge the mortgage's outstanding debt, the court will scrutinize the sale with particular care. There is recognition that the fact of repossession can taint the property, so resulting in it only being capable of sale at a reduced price. The mortgagee will not have breached his duty unless he plainly on the wrong side of the line. The mere fact that a higher price might have been obtained does not inevitably mean that the duty has been breached. The burden of proving a breach of duty by the mortgagee rests on the mortgagor. So based on the facts of the instant case and the principles set out above, I see no basis on which the exercise of the plaintiff's power of sale can be either questioned or fettered, save and except in the event that some doubt
But the client said, they didn't have no more than. She showed me what they had.
Tony, we could hear you, you know.
Good afternoon, sorry for
Yeah.
being late.
That's all right. We just started a few minutes ago. We were on this case of Teresita. So in the next Bahamian case, paragraph 25, the Court of Appeals
Doctor,
said,
I don't know if you could hear me, but I
I can hear-
can't hear a word you saying.
but I could hear you. I could hear you very clearly. You heard me?
Yes, I heard you, Ms. Archer.
Okay, what
You were
happened?
saying paragraph 25. This one we have stop at 22.
I say 25, I say 21.
Okay, I thought you said 25.
Oh, 21.
Okay,
So
okay.
in Citibank versus Major, in the Court of Appeal decision by Singh, he said the case cited on the impeachment of mortgage securities all show that unless there is a mortgage action in which is raised a serious question to be tried involving the validity of the mortgage transaction itself or fraud or irregularity in the exercise of the power of sale, the courts will not intervene to prevent a mortgagee from exercising his lawful right under the mortgage deed. Because you've seen the trend from all of the cases where even though the defendant presents their, I guess, their defense, even some admitting that they haven't paid it in years, that the court still grant the bank, the mortgagee, their right. And you see what he says in paragraph 22. He says that the court itself will strike out the order if it discloses no reasonable defense, is frivolous and vexatious, and is an abuse of the process of the court. And the judgment went against Teresita. So when we look at a mortgagee, remember mortgagee, we could be a bank, it can be an insurance company, it could even be a private lender. But in most instances, it is a bank. And a bank itself has certain duties just in being a bank. And once you establish a relationship with the bank, whether that is opening an account or applying for a mortgage or investments, getting an investment portfolio, there are certain common law principles that actually are enshrined in banking law. So when you talk about a banker-customer relationship, it is a contractual one. And when you have a banking relationship, the customer is the creditor and the bank is the debtor. Because of course, you know, the deposits are always on the liability side of the balance sheet, which makes them a creditor. And it's reversed when you have a loan. In that relationship between the customer and the bank, there are also express and implied terms. The express terms is what's stated in the contractual agreement, and the implied terms are the terms based on common law. So one of the primary duties of the bank is to act as an agent for its customer. And in order to carry out its contractual duties, the bank has to always make sure that its employees have the requisite skill, that they carry out the due diligence that's necessary, and their standard of care is higher because it is an actual professional entity. And also remember that a bank itself has the duty of care in tort. And that means that if any employee of the bank makes a misstatement following an investment, or if they give advice and the customer relies upon it, then of course the bank can be sued. Also be mindful that the relationship between the bank and its customers is a fiduciary one. And that means that that relationship is based on loyalty, confidence, and trust. And that's why whenever there is a matter before the court, they always look at the documents and construe it against the bank, because the bank is the one that's supposed to be the professional with all of the skill and experience in order to make sure that not only they are protected, but also their clients. So banks also owe a duty of confidentiality, and that duty can only be disclosed under 4 circumstances: compulsion of law, and that includes a garnishee order, or when you have to file with the FIU for some suspicious transaction, or you have a request from the AG's office asking for information, or a request from the police. The second one is if the matter is in the public's interest. Third, if it's in the bank's interest to disclose, or is based on the customer's express or implied consent. And that's why I always advise students that when you open an account, whether that account is with a bank or with an investment bank, you must always read the terms and conditions. The bank is also required to provide a statement of account to its customer periodically. If you have the time, you can read the case of Makushla Pinder versus Scotiabank. And in that case, her ATM card was being used fraudulently. And Scotiabank refused to give her funds back, saying that she was at fault and that she should have reviewed her statements online. And she argued to the point to say that, one, you did not advise me that no more statements were coming. Two, you didn't advise me that I should go online. When these incidents happened, she was not on the island, but Scotiabank refused. The second time when it happened, she took them to court and she won. So if anyone is interested, I could send it to you. It's 30-something pages long. Any interest?
I would like to see, please.
Okay.
Yes.
Yeah, it's a very good case.
I actually had the opportunity to hear some of the evidence of the case while the trial was going on. And I will admit I was surprised that Ms. Pinder, that this matter was found in her favor.
You were? Why were you surprised?
It really was, because how many, okay. Based on the evidence, it wasn't as though it was a phishing scheme or anything like that. Somebody was actually physically using her card to withdraw funds from the ATM. Then she gets a new card. So how does this person get access to your new card now? And how is this person, again, for a second time, able to access your new card and withdraw funds?
You're a banker. What do you think?
No, I'm not.
You're not? Okay, let the
I am
bankers
not.
let the bankers tell you.
Thank you.
Bankers? Okay, bankers. Hold on, I'm trying to find a case for you right now. I have it saved. But some bankers should tell you. How do you think that happened?
It's not someone accessing a card? Oh, inside job. Okay.
Thank you.
Gotcha.
Thank you.
Yeah, because guess what? I had some clients a couple of weeks ago that had a problem with that same bank, with almost like that same situation. And they literally had to move everything from there because it kept happening. They changed the cards, credit cards, debit cards, accounts, and it kept happening. So they literally, they're now um, in court trying to get it solved because thousands of dollars is missing. Cards are run up to the fullest, and half of the time they didn't even use the card. Half of the time, like they didn't even get the card, went in and signed for the card, but the card was used. It's a messy situation. So
I
they
mean,
had to
that
literally,
person still there.
yeah, they literally had to remove themselves from that bank completely. And now it's in court.
Mm-hmm.
Thank you so much for that clarity, because I really did not understand what was happening with Miss Pinda and her card. Okay.
I'm not a banker, but I was gonna answer you too, because it happened to my husband, and it was during the pandemic, and they had to stand outside and give the card actually to somebody in Royal Bank. And during that time, while he was on the line, someone withdrew funds off of his account, and Royal Bank was saying no. It was a mess, because dealing with the police station, Royal Bank don't help you. Have to ask them to request to play the tapes. It's a mess, but it happens, and they do it all the time. So you have to be very vigilant with your funds online.
So this account that she had was a savings account. She and her mother on this account. $30,000 something. And all of a sudden her money started to move. Hold on, I'm about to send it to you right now. I'm about to hit send. It was a very, very good case. Okay, you should have it. And I think in this case, the bank's attorneys should not have, the way in which they presented the case, to me, left too many holes in the whole matter. Because they relied on the PFSA, the contractual agreement. And they're saying that she had a duty to monitor her account and to promptly advise them if she saw any unauthorized transactions. And the first thing is the dates when it happened, she was not here.
And then if I recall, another thing she was saying is that she never withdrew funds from the ATM. She always went into the bank to deal with her account.
And she even spoke to the branch manager. And he did nothing. And it kind of alluded to the second time when the funds went off her account that she knew the person.
Yes, that was the impression that I was getting when I was hearing the evidence.
She notified the branch manager twice. And you see the loss she suffered off her account, $27,500. So this was a very good case on the bank on its duty to its customer. Because once you have an ATM card, it's your duty as a customer to ensure that no one has access to your passcode.
And see, that's another thing too, Ms. Doctor, because if you're a person, okay, honestly within yourself, that I'm the only person that used this card. And then certain things start happening with this card. You make your way into the bank, you make a complaint, okay, there's going to be an investigation. 2, 3, 4 weeks, you're still waiting to hear from the bank. These things are happening. You go in and you ask, can I change my card? Can you put a stop to my card? I don't want this card no more. And they tell you, oh, we're still investigating. Just don't use the card. And next thing you know, all your money gone. Nobody has no explanation. Oh, we're still investigating, but I'm not using my card. Okay, they give you a new card and the same thing happens again. I mean, come on, someone have to have some kind of answers for you.
Even though they had the investigating officer, he said, he came back and he said the same thing. It's her. In paragraph 28, he said, due to the fact that all of the disputed withdrawals were actioned by the card issued to Mrs. Pinder and the corresponding PIN and were not disclosed to the bank within the 30 days. Remember now, they used the clause as in the PFSA. And after they occurred as settled in the bank standard agreement, the bank decided to refuse to refund her money. So if she is not on the island and someone used her card here in Nassau, how is that possible?
How is that possible? How? And she can prove that she is not here and she has the card in her possession.
Mm-hmm.
So at the end of the day, it makes you feel like you have to go and prove this situation to them. That kind of way, like you have to go and do your own investigation. You have to, and have you thinking, really, I feel like I doubt myself. And
Exactly.
it's like, no, yeah, my card is being used in Fort Lauderdale and I'm in Freeport. Come on. But at the end of the day, the bank doesn't feel like they should take any losses. The
No.
losses should be on you.
Now, don't forget now, the bank itself, as a global bank, it gives you the operational loss for the year. So there's no way they were going to absorb that loss.
No, not at all.
Heads would roll.
I think too, and that's why it lingers so long, because they want you to give in and say, whatever, I'm not even gonna fight it anymore. It's a done deal. I just prefer to move my account and take it somewhere else. So at the end of the day, you lose. And they still stand their ground and they still win.
Yeah, I'm trying to find this. It just was, even though the bank staff gave evidence, it just didn't add up. Because it says in the case of the transactions involving Mrs. Pinder's card, the bank was able to determine that the correct PIN was used. Someone in that bank knew how to do it. Someone knew. If she only has one card and the card is with her, how did it happen? So the corporate security investigation, Mr. Smith, officer, senior manager, he came to give evidence as to explaining what skimming is. But I don't think that was skimming, because he couldn't figure out how it happened. I tell you, it was 30-something pages of 79. I know there's plenty. And even Scotiabank brought in the video footage. In paragraph 58 at Rubis service station. So they say, by the time they came to the court, of course, the footage had been rewritten or overwritten. So they couldn't prove who these persons were. Yeah, a lot of people were surprised that the court actually awarded her money. He said, I take special note that neither counsel cited the case of Barclays Bank versus Quinsacare, in which Judge Stein set out the following. The relationship of customer and banker is primarily that of debtor and creditor. However, in addition to that, the banker acts as the customer's agent in paying the customer's checks against the customer's money in the banker's hands. The same relationship applies where the banker acts on the customer's order to make an immediate money transfer. An agent owes a principal a duty to exercise reasonable skill and care in carrying out the principal's instructions. Therefore, a banker owes a customer a duty of care in tort to take reasonable care when making such a payment. And this duty is implied so and their flippant attitude at when she first came there saying that her funds were missing, they dismissed her. And then they allowed those persons to go back and take more funds off her account. See, he says in paragraph 111, he says in the instant case, Mrs. Pinder notified Scotia as soon as she became aware that funds were being withdrawn from her account. And what is even more egregious is that even after notifying the bank, further transactions took place. And therefore, in my view, it is the defendant who was seriously negligent. The defendant's claim of negligence on the part of the plaintiff is wholly unsustainable because the bank had a duty of care. So now you have to keep checking your statements, checking your account online. So the general rights of a bank. The bank has a right to charge the customer a reasonable commission for services rendered. They have a right to demand repayment of any loan. They have a right to exercise the lien over any customer securities deposited other than the items held in safe custody. And I think most of the banks now have already gotten rid of safety deposit boxes, correct? Because I know a lot of them were trying to get rid of the.
Bank of the Bahamas still have safety deposit boxes.
Are they active?
Yeah, and Commonwealth Bank.
Canadian banks trying to get rid of them. Because that's a lot of work.
It is.
Especially when they become dormant.
Mm-hmm.
And those and whatever's in the box has to be transferred. Okay, the banks have a right to be indemnified by the customer for any expenses or liabilities incurred when they act as agent of the customer. They also have a right to return unpaid any customer checks where there is insufficient funds. They have the right to set off, and they also have a right to combine accounts. So that's the rights of a bank. A bank also has, that's the rights, and I gave you the duty. Now let's talk about the customer. The customer has a duty to pay reasonable charges for services rendered. And you know, under the Banks and Trust Companies Regulations Act, whenever the bank is increasing or changing its fees, it has to give its clients notice. The next duty to the customer is to issue checks only if they have sufficient funds. Because if you write a check and there's insufficient funds, then it means that you're asking the bank for a loan or overdraft. And the bank can't say no if you don't have an arrangement in place. The duty of the customer is to also exercise reasonable care in drawing checks to avoid fraud or forgery, which means that you have to secure your checks. You have to make sure when you write a check, you fill out all of the sections of the check. The duties of the customer, again, is to advise the bank of any known forgeries. And that's what the bank was relying on in this case of Mukesh Lapinder. The rights of a customer is the right to repayment of funds deposited on demand. So that means that when you walk to the bank, if your balance is $101.50 and you request that, they have to give it to you in any denomination and fashion that you want. If you want it in cash, it'll be at your own risk. They also have a right to have the bank discharge its duties to them because it is a contractual arrangement. They have a right to have funds deposited, appropriated to a specified account to cover checks that they want to pay. So you can't do that when you make a deposit. They say that you want this deposit, specify that this deposit is to cover whatever's and any other check that's coming in to be cleared. Now, as a mortgagee, the bank has rights. And you know they have the right to possession. A legal mortgage entitles them to possession of property. So as soon as security over the property has been executed, and even though there has been no default on the mortgage loan, that right still exists. So notwithstanding that right to possession, the banks are normally reluctant to go into possession due to the inconvenience administratively. So normally you notice in all of the matters we've looked at, they go for a right to possession, but then they want to exercise their power of sale. The bank has a discretion to adjourn proceedings for possession of mortgage property, particularly in the exercises of their power of sale. So as a mortgagee, the bank also has a right, statutorily and contractually, to exercise their power of sale. So the mortgagee, under the mortgage loan agreement or the indenture of mortgage, in the event that the borrower defaults under the terms of the mortgagee may sell the property, the mortgage property, in whole or in part, and such sale may take place by auction or private contract. So even though the statutory power of sale arises when the mortgage money becomes due, it cannot be exercised until one of the following conditions has been met. And that's the demand for money, demand for payment, followed by the default continuing for 3 months, or the interest remaining in arrears for 2 months, or the breach of some covenant, either the payment of principal and interest. The third right that the bank has as a mortgagee is the right to additional property. So since the mortgage of land includes fixtures and anything subsequently affixed to the mortgage property after the security has been executed, the legal mortgagee is entitled to the additional chattel on the property. Fourth, they have a right to documents of title. The first legal mortgagee is entitled to all the title deeds, though the mortgagor may inspect and make copies of them at his own expense. The fifth right is the right to protect the property. Most mortgages contain terms regarding the borrower's obligation to maintain and insure the mortgage property. And we discussed this last class. However, the mortgagee has a statutory and common law duty power to prevent deliberate damage, carry out necessary repairs, and insure against fire. It should be noted that if the mortgagee goes into possession of mortgage property to carry out repairs, it must account strictly for the work done. The right to insure against fire is only to the event of 2/3 of the reinstatement value and does not cover other risks. The next right the mortgagee has is the right to track. As a secured lender, the mortgagee has the right to add further monies to the security so that the monies are also secured. And you might know that's what they always put in it. I know Scotia has it, the all monies clause for whatever else you owe and any other thing that they had to tack on and add it to your mortgage. The mortgagee also has a right to appoint a receiver. And that receiver could be to collect the rents from the tenants on behalf of the mortgagor as his agent. The receiver's cost will be a debit to the mortgagor, and the terms of the appointment may exclude a bank's liability for monies it does not receive. Lastly, its right to consolidate. The bank may consolidate mortgages, although banks take all mortgages, which eliminates the need for separate mortgages. Because that's what Scotia tried to do in that case. So they didn't put in the all monies clause. Now, the duties of a bank as a mortgagee is one, investment advice. So when a bank gives investment and or lending advice, it owes a contractual duty and a tortious duty to take reasonable care in the provision of such advice and must not do so negligently or recklessly. The duty to take reasonable care in providing advice is more pronounced in instances where the banker advertently and personally assume the responsibility of giving and or voluntaring investment advice, and the customer reasonably relies on the statements made by the officer. I think you'll see now a lot of cases are coming up with foreigners who are suing banks and or investment funds, saying that the whole setup is a fraud, with different excuses as to why they relied on the advice given to them by the investment fund advisor or from the bank itself. However, where the ordinary business of the bank does not include providing advice on the viability or prudence of residential or commercial projects, the customer must make it clear to the bank that its advice is being sought and not make a mere request for a loan. In order for the bank to be under duty of care to the borrower and potentially liable for negligent advice. Banks also have to be prudent and aware that in merely providing information to the customer, they are still under duty of care to ensure that the information provided is accurate. In the ordinary course of the bank services, without any effective disclaimer and upon which a customer will reasonably be expected to rely will attract legal liability to the bank if such statements made by the bank's officers have actual or apparent authority when they make their statements. The exercise of the power of sale is, as we saw in the case of Finco versus Teresita. The mortgagee has a limited or equitable duty to the mortgagor and any guarantor of the mortgage's debt to take reasonable care to obtain the true market value of the property at the date on which it decides to sell. The mortgagee does not have a duty to take any action to preserve the value of the security in the exercise of its security rights ahead of obtaining possession and control of the property, of course, subject to the mortgage. The bank does have a duty to account for the proceeds of the sale of the mortgage property, since it is a trustee for such proceeds for the beneficial interest of the mortgagor. It must pay the mortgagor any surplus of the proceeds of sale after the outstanding mortgage principal, interest, and all bank expenses associated thereto. Real property tax. Where mortgagee is exercising his legal remedy of power of sale and acts as a vendor of mortgage property, it conveys the mortgage property to the prospective purchaser, subject to its right and equity of redemption. The power of sale and other remedies of the mortgagee need not be expressly transferred, since they are normally expressly conferred by the mortgage deed, and therefore made exercisable by the mortgagee and its assigns, and will pass to the purchaser without mention. It should be noted that while there may be no commercial obligation by the mortgagee to pay the outstanding real property taxes on the mortgage property or incur legal and administrative costs in the exercise of the power of sale, the outstanding real property taxes represent a first charge over mortgage property. And then notice that real property taxes can be assessed for 10 years retroactively. So under section 16A, sections 1 and 2, it appears that a mortgagee is deemed to be the owner of the reference mortgage property and liable to pay any outstanding amounts due and owing in relation to real property taxes assessed on the property. So such liability or legal obligation should not in itself deter or in any way delay the sale of the reference mortgage property, because the purchaser may agree in some instances to accept liability for the payment of outstanding real property taxes on the mortgage property only after the sale of the property and subject to receipt of some indemnification, guarantee, or assurance on the part of the mortgagee as the perfection and efficacy of the secured interest being sold. Now, one of the liabilities of a mortgagee is undue influence. And this is where one party has obtained a benefit by reason of the exercise of influence over another person. And it is manifestly disadvantageous to the other person, and they will be set aside and considered void or voidable. Undue influence is normally based upon a special relationship, husband and wife, doctor and patient, attorney, client, parent and child, banker and customer. Banks should be particularly aware of the concept of undue influence, as a third party, spouse, parent, or child may grant a guarantee or other security to it over the family home to support the borrowing of the contracted party of primary borrower of the bank. Now, I know normally when you have any relationship, such as these special relationship, you normally ask the client to seek independent advice. If the primary borrower defaults and the bank commences proceedings for possession and exercise of the power of sale, the guarantor may allege that there was some undue influence, either wielded by the primary borrower over the guarantor or the bank itself. Anybody have any current stories they want to share with undue influence? I couldn't find any local cases.
I don't have a current story, but I have a story that happened many years ago. There was a case where an aunt had her niece living with her, and the aunt wanted to come and purchase a home. And she was applying for a government-initiated home and had gotten an assignment, a lot assignment. So the problem for the aunt was that although she had a pretty good stable job in a government institution, she was basically maxed out with loans. And so she was not able to support a mortgage with salary deduction. And she had attempted to get a mortgage like 3 or 4 times and was turned down each time because of her outstanding debts. So out of desperation, she spoke with her niece who lived with her at the time, trying to coerce her into signing on with her so that she would be able to qualify for the home. However, like you could tell that the niece was under duress and that she really didn't want to do, to sign up with the aunt, but she, under the circumstances, because she lived with her, and I guess her aunt, was very persuasive and also very sort of demanding, she was afraid to say no. And so as a result, even though everything was explained to both of them, at the time present, they were both present. After the conversation with both of them together, the niece called and was sort of apprehensive, and she said she wasn't sure she wanted to sign on and everything. And it was thoroughly explained to her that, remember now, if you sign on for this is a 20-year mortgage, which also is going to garnish your wages and prevent you from doing something on your own. So in the end of it all, the niece, I guess, stood up to her aunt, and she decided that she wasn't going to do it, although she was afraid, because she said, she lived with her and she knew that her aunt was not going to take it well if she said no. And so eventually they couldn't do it anyway because it was just too many debts involved, and she really couldn't qualify. She was just sort of grappling at straws, really.
Oh, yeah.
So it never went through, and thankfully for that, because her poor niece, I think she really felt that she was being almost blackmailed into it.
Anyone have an example of husband and wife? Because the English case cited here, Barclays Bank versus O'Brien, is husband and wife. Anybody has a local one? This one is in 1990. O'Brien, 1990, that was appeals case. The husband persuaded his wife to mortgage their matrimonial home to Barclays so as to secure an overdraft for his business. And the husband misrepresented the true extent of the liability under the overdraft. The branch executing the mortgage had received but ignored instructions to ensure that the wife was aware of the risk and to advise her to consult an attorney. When the husband defaulted, sought to enforce the mortgage. That's Barclays. And the wife claimed that the mortgage was avoided against her due to the misrepresentation from her husband. And the court held that the mortgage was avoided because the wife, against Barclays, as the wife, no, the mortgage was avoided against the wife as Barclays had constructive notice of the misrepresentation by the husband. And the judge, Lord Brown Wilkinson, said there are two classes of undue influence. One is actual undue influence, and the second one is presumed undue influence. And he said actual, he said in these cases, it is necessary for the claimant to prove affirmatively that the wrongdoer exerted undue influence on the complainant to enter into the impugned transaction. And class two, which is a presumed undue influence, in these cases, the complainant only has to show that there was a relationship of trust and confidence between the complainant and the wrongdoer. It is presumed that the wrongdoer abused that relationship in procuring the complainant to enter into impugned transaction. So it says a wife can set aside a transaction procured by her husband through undue influence, misrepresentation, or some other wrongdoing. Not only against a husband, but also against where one, the husband is acting as agent for the bank, or the creditor has actual or constructive notice of the wrongdoing. So a creditor has constructive notice of the wife's rights where he is put on inquiry, and two, he fails to take reasonable steps to satisfy himself that the wife's agreement to stand on surety has been properly obtained. The bank has to take reasonable steps. Once on inquiry, the creditor can reasonably be expected to bring home to the wife the risk of standing as surety and advise her to take independent advice. And these requirements can be satisfied if the creditor insists that the wife attend a private meeting with a representative where she is told of the extent of her liability, warned of the risk she is running, and urged to take independent legal advice. So for those who actually still do mortgages now, I know independent legal advice is always required when there's a familial relationship.
Yes, we do require independent legal advice.
Mm-hmm. But even though you get it, sometimes I think some of them is still under influence.
Yes.
They're still under
Because you have
influence.
so many persons who are just so desperate. They don't care who signed with them and they don't care about that person's future.
Mm-hmm.
They just they want a mortgage now.
Yeah. They
So
don't
whatever
understand.
it takes, that's what they're gonna do.
They don't understand what it means to get a mortgage. But I mean, I think some understanding now. Yeah, it's a long debt.
Yep.
So
Big debt.
You see that all the time with parents that are, maybe already hitting 50, 55 even, and they'll come requesting to get a mortgage to purchase a home, and they'd want to sign on all their children on with them, which, and even though you express it to them that, hey, this is a long-term debt, if your children are married, it's going to be an issue. If they're unmarried, it'll still be an issue. And you're also going to be preventing them from being able to do something on their own because they'll be tied to this. And you'll find with a lot of parents, they would have these children sign up and they would have that one child that they favor who's probably the vagabond in the family that isn't gonna assist with anything, isn't gonna make a payment, isn't going to contribute. And that particular child is the one they leave everything to, while the other child takes on all of the responsibility and burden and ends up, they end up causing a lot of problems within their family because of that as well.
Mhm.
I was
Yeah.
just gonna say that, Michelle, we have a lot of cases with parents. I don't understand our culture with that. We have a lot of Bahamian parents coming and bringing like their 21-year-old, and it's like, it's such a huge responsibility. Like, if this child plans to have a future, it's like you already signed them to a 25-year debt. Like, it's so sad. It's almost like they feel like the kids are obligated to do it.
But I could give you an instance where I was in court and I saw where the judge was speaking about this lady's home. They wanted possession, and the judge asked the mortgagee, do you have any children? And she said yes. What ages? She gave the ages. And so he said, well, maybe you should get your eldest son to come and sign on with you to help you pay for the mortgage. Why would you saddle down someone who is 20 years old with a mortgage?
Exactly.
Is that good financial advice?
No.
No.
No, it's not.
No.
Because the 20-year-old, he's going based on his current situation. Now, when he finds a woman and they get married and they want to get their own home, that woman now is at a disadvantage because her husband is on a mortgage with his mommy
Exactly. And the mommy is in the house.
and
And they're
mommy
not
in the house,
there with the mother.
mommy and the rest of the children.
Yeah.
I know of a case where there was a mother, she had 3 or 4 children. Children are all grown, but at some point she fell into deep arrears and she was going to lose her house. The bank was going to foreclose on her. And her son, who happened to be a police officer at the time, he stepped forward in order to save the house. And what they did was transfer it to him, and he took over the mortgage in order to save her house. He was, I think, married at the time, but eventually became divorced and moved on with his life. But in the interim, between then and now, she got married to a younger man than herself, who she promptly moved into the house. And her son became agitated because there he is paying for the house, paying the mortgage. And his mother is living now in this house with this younger man who, in the son's mind, isn't contributing because it's not like they're paying the mortgage while living there, because his wages are garnished with salary deduction,
Yeah.
being a police officer. So at some point, he was even telling them that they had to, move out of the house. And of course, they became agitated because they weren't paying the mortgage, but they were maintaining and upkeeping the house and the yard and doing little things, to make life comfortable for themselves. And in the meantime, I think one of his sisters, who has a few children, is living in the house along with the mother as well. But that's just another example of the way parents, in her case, she didn't really coerce him. He did it because he knew she was about to lose the home.
Right.
And, even as well-meaning as that was, at a certain point, he had said when he wanted them to move out of the house, he said he had a sale for the house and he wanted to sell the house and buy something else for himself. So the mother was more agitated because, as far as she's concerned, now you're trying to steal my house from me because I put a lot of money into the house in paying all the years I paid, and then I fell into hard times. And yes, you took it over, but I still was maintaining the house and paying the bills for the house and doing whatever to the house. So she felt some sort of way about him wanting to sell the house. And he even, said, well, okay, if you all want to buy the house from me, that's fine. Of course, they're not in the position to do that. But I think his whole reason behind it was he became agitated with the new husband that she acquired. Okay, it's, the old saying, there can't be two women living in one house.
Yes.
And I think in his mind, even though he wasn't living there, because he was stationed on one of the islands in the police force. So whenever he would come to Nassau, he would also stay in the house. But he wasn't there permanently all the time. So he wasn't utilizing the space and enjoying the house that was, being paid for by him. His mother and his sister still were. And of course, the husband that she acquired. And so in his mind, he was probably thinking, well, if he's going to marry you, he need to take care of you and put you in a house of his own.
You know what I always wondered, Ms. Archer? Okay, you say you and your son sign up for a mortgage. He pays half, you pay half. Okay, today or tomorrow, he no longer has a job. You can't afford the mortgage. You lose the home. Is it supposed to be a situation where, okay, we go in for a mortgage and today or tomorrow, I can't afford to pay, you should still be able to pay? Do we look at mortgages in that way?
What do you mean? He
Okay.
can't, but she could pay all of it?
Yeah, if he loses his job or if she loses her job, can the other or can the other still afford to pay the mortgage? Because if we're going in it as a partnership, half, and one of us loses our jobs, how is the mortgage going to be paid?
Well, now you have to step back first. When you would have actually calculated for the mortgage, for the approval for the mortgage, you would have looked at the debt servicing of both individuals. And that's that depends on whether the credit committee is willing to take that risk because that is the risk that if one cannot work or one is working, can the other one carry the mortgage load?
Yeah.
And if the answer is no, before the mortgage is granted, that is a risk that the bank has to look at.
In most cases, most banks, they will make sure that they grab salary deduction from wherever is most feasible. So you may have a partnership, you may have two persons on the mortgage, but one may have a, nice job that supports salary deduction, maybe 100% of it. And the bank will say, well, okay, we'll take the salary deduction and you guys will have to work it out amongst yourselves as to who's going to pay half or who's, if one has to pay the other one in cash half of whatever or whatever it may be. But that's how the bank will look at it because they want to just make sure they have automatic payment. Now, if the other person loses their job, the bank still expects to be paid in full.
Yeah.
Whether half of the person, half of that partnership is unable or not.
So true.
Yeah. So it'll be like the case that we read earlier, a couple of classes back. Remember when the wife was paying, her half was coming out of her salary?
Yeah.
Right. And he was not paying.
He was not paying.
The mortgage is still in default.
We get that a lot too, especially in cases where one of the parties moves out of the house. They may not be divorced, but they just choose to separate. And the one party who's in the house would still be expecting the other party to pay. And that other party that's not there anymore, at some point they become disgruntled and they be like, okay, I'm not living there anymore, so I'm not paying. Even though the mortgage may be in the names of both parties. But that happens a lot and then the person who is living in the house, they seem to be shocked and surprised when they realize, this person hasn't been coming in and making their portion of the payment.
Mhm. Okay, Ms.
So-
Archer.
Mhm.
Sorry.
Go-
No, you can finish.
Go ahead, Tony. It's okay.
Okay, I have another question. Okay, I have a friend. He pays the mortgage. It comes out of his salary, but the mortgage has both of their names on it. They are getting a divorce. They don't have any underage children. They have 3 kids, all of them are off and grown. Now, he's saying that he's gonna ask for the house. Can he do that?
On what grounds are you asking for the house?
Because he pays the mortgage and it comes out of his salary. There's no evidence that she pays anything because it comes straight out of his salary as a salary deduction.
But she doesn't do anything to the house at all?
He buys the grocery and she lives.
Oh,
He can show where he pays the light bill and the water bill. He takes care of his home,
A stone.
but
she
the
buys
mortgage is in
stone?
both of their names.
No, if she buy a stone to put in that house, the judge is gonna look at that. If
I know
she's-
all of that.
I had a case
I
today.
can barely hear what y'all say, and y'all are very low.
yeah, very low.
Talking
Go
You
ahead.
couldn't hear,
about-
you couldn't hear me?
No, we could hear you, but someone else
Okay.
is,
Can't hear me, eh?
go ahead.
Okay, so you can hear me now?
Yeah, we could hear, I can hear you.
Okay.
You
so
sound
the judge-
distant.
Oh, I don't know why. The judge ordered it was a married couple, they were getting divorced, they have no kids. And he paid all the mortgage. But the judge ordered him to pay her like 40% of what the house was valued. Because she used to clean and she bought some furniture and she paid like a cable bill and just 1 or 2 things. And he is now seeking financial assistance to get 40% of what the house is valued to pay to her. So that don't automatically go like, even though I paying the mortgage, because once she could prove that she is even assisting by cleaning up in the house or by.
Wow.
Sound like she was
I-
doing it both.
I met that same client today. I believe it's the same client. And he said today that she had left him for over 10 years ago. She packed up of her own accord. He didn't put her out or anything. And he came home that day and the house was cleaned out. He thought he had been robbed. And he said she still today has a key to the house. He never put her out of the house or anything, never disenfranchised her. And when they went to court, she didn't contest the divorce. She told him, oh, give him the divorce. I don't care, and the only thing is, so now she wants interest in the house, but the house her name is not on the mortgage. But she wants interest in the house, even though she left him of her own accord. They apparently, there was no reason from his side of it. There was no reason. And you're right. This particular person said they have no children. So I don't understand why the court would actually grant her all of that. And now he's faced with the fact, he said he would rather pay her out before he would allow her to have his home. And he went further to say he'd rather burn the house down before he would let her have the home.
Because Michelle,
How long did
you have to read the case, because men could tell you anything. He could have been doing a lot of things. I don't believe him. And that's neither here nor there. But once I sit in that house and I make a bed, buddy, I could tell you, I can get something. You don't think that you can just throw me out the house, even though I'm not paying any mortgage and I don't get anything. Like the guy said, I'd burn it down first.
Well, he claimed that he didn't throw the wife out of the house, and he didn't even change the locks, that she still had a key to the house. And I guess in effect, he probably at some point had thought she would come back, or had hoped she would come back, I guess. I don't know. But this man had tears coming out of his eyes. I mean, honestly,
Sure.
if he
I'm
was
sure.
lying, he was really
It's
convincing.
crocodile tears.
They are really good. Men are very good at performing. So I mean, I can't say what happened, right? But
Hold on, Ellsworth is on this call, you know.
and they are very good, they know how to put on a show. But the judge ordered that he must pay. He has
Well,
to pay
but to the judge's credit though, he ordered that the husband gets 60% and the wife get 40%.
That's fine. She still gets 40%. And like, I think she moved on with someone else and he was hurt.
Maybe that's what it was.
Yeah.
It had to be.
Yeah. Yeah. So she actually got 40% just for being a wife. Just for
40%.
cooking and cleaning and
She-
Performing her wifely duties.
yeah. Yeah.
What I think was peculiar though, to be separated for 10 years, right? And you don't show any interest. You seemingly don't care about whatever it is. Because he said when she moved out, she took everything, except she left him a bed, one TV, the fridge, the stove, and that was it.
What?
But
What?
That was
everything else,
okay right there though, when she took everything.
right? She took everything else of value out of the home when she left, and she left when he wasn't there. So they didn't have a discussion over it, or it wasn't an agreement or anything. He just came home from work and found that his house had been ransacked. And he said he thought he had been robbed at first glance. He was like, somebody must have broken into the house and stole everything. He didn't realize at first it was her.
Oh, so 10 years later now, they gave her 40%?
Yes, that's the part I don't understand though. I mean,
40%.
especially if you
but-
take most of the valuables with you when you go and you wait this long, she apparently she did not initiate the divorce. He did. She did not contest the divorce. The only thing she did was she sat and waited for the divorce to come through, and then she said, well, I want the house. And he said he can prove where his, every payment for that house came out of his salary from the beginning straight through, that she never contributed to that.
And how long?
Even
Minus the 10 years.
how long were they married?
Uh.
I think like they were married like probably like not like 15 years. But it wasn't that long. But you see, even
You mean
if-
15 years inclusive of the 10 that they were separated, right?
yes.
Yeah.
But then, Michelle, even you have to look at it even in the 10 years, if she even came back to that home, and let's say they even like had any physical interaction, that's null and void, that 10 years.
Yeah, that's true.
Yeah.
So I don't know if he's telling the whole truth in what happened. I just think his feelings is hurt a little now. And I think that he's hurt that he has to pay her 40% knowing that she didn't contribute financially. And that's a problem like what men have. They feel like once they're contributing everything financially, they are entitled to 100%, but that can't make a home. And so that's how the judge look at it.
Well, he was
So
very
what's the-
sad. He was
Yeah.
very sad. He said she left him high and dry for him to fend for himself. And he was in that house all alone by himself, fending for himself. And I mean, this gentleman was like on the verge of tears, literally. But, I don't know. I didn't ever see her or anything like that. But just from him, I think he kind of let himself go a little bit.
Oh,
So,
okay.
he maybe his life hasn't been, all that exciting.
Not as happy as her.
Yeah, not
she
as happy
moved
as
on.
hers, because if she
She
moved
have a
on
new
with someone else,
boyfriend.
she's probably happy singing every day.
Right.
But, clearly he's very lonely, and, I guess things just haven't been the same for him ever since,
I can need him to get it together. And that's why I would tell any woman, I always tell them if they're on the mortgage, if they're not on the mortgage, just buy a set of sheets once a month and just make a bed, make a home,
What?
buy some towels,
Where is,
buy
we only have one man on this call and elsewhere is so quiet.
Yeah, a set of sheets are very intangible, though. You have to do something tangible, because when you pack up your little suitcase to leave, you could take those sheets with you. And those sheets don't count after you grab them up and take them, unless you're going to split them in half and you give him half the sheets and you take the
No,
other
but
half the
then you
sheets.
could tell the judge that you made it a home. You brought stuff into the home and you made the home a home. You
Yeah, but
understand?
guess
You
what?
bought grocery
People
stuff, you
who
made
people who
that
are
home.
renters, tenants, they make the home a home. That doesn't
That's
mean that they're
different than a
entitled to
marriage.
grab
That's
whatever it is.
no, but that's different than a marriage. They look at marriage differently than tenants.
But
Yeah.
marriage is also a contract. So there are
Exactly.
certain expectations in a marriage, even though, and be a helpmate and take care of him and look after him and stay.
What if she found somebody else?
Exactly. Who was helping her?
Oh, Lord.
I mean, where we work is very strange. I'm sure you would see a million cases like this. If you sit down
Yeah.
one day, it's
It's,
not probably exciting as the bank, as the commercial banks, but we have our share of stories.
We
yeah.
have a different kind of excitement than they do.
Yes, the stories are a little bit different.
How?
Ours are more bizarre.
Yes, that's the word.
So where do you ladies work?
I don't want to
Ours
say.
the same.
Okay.
Let me look at the link. Oh, I know. That's those expensive homes.
Quote, unquote.
Very expensive.
Oh, boy.
Yeah, but I just wanted to know if that's how it just worked, because I mean, hey, you've been paying a mortgage for 20 years, and all right, and that wife
Yep.
is making that home a home, and at the end of the day, it didn't work out. Is she entitled to anything?
Yeah, she is.
Seems like she is.
Yeah, she
40%.
Yeah,
It depends on the judge too, doesn't it? How extreme that will get.
yes, the percentage wise. But as in a marriage,
Mhm,
I don't actually have to give money. When you come home,
mhm.
I your back,
Make that home a home.
make your favorite dish all the time.
Yes.
Air the house, make sure the sheets are clean. I mop the floor. I listen to all your work stories, all of that. You putting your stress on me. You have to pay for that.
And you're taking care of the children, even if it's a case where she's not working and she's at home, taking care of the children, being a homemaker and a stay-at-home mother. All of that is considered input.
And guess what? It's the same thing as if she was out there working and paying the mortgage and he was at home.
Yeah, okay.
So if he's painting the kitchen wall once in a while and fixing the little fittings underneath the toilet and stuff like that, making up the bed and being ready when he comes home, you have to pay for that when you
Yeah.
decide you're going to separate. It doesn't come free.
Not to mention the extracurricular stuff.
Of course.
And
Of
that's why
course.
my thought of from now, like when you have your own, like you build your own home and you're not married yet, do not bring a man in your house. Y'all go find an apartment, because once he moves in, that then becomes a matrimonial home and then he has shares in it. It's not gonna
Mm-hmm.
happen. So y'all go find an apartment and y'all build something together, but that is yours.
Yeah, but you still, you don't forget now when they do whatever.
Yeah, that's true, but I only could try. She's 14. I ain't gonna try
You,
from young.
you're right. You only could try.
Tell me something, even if you don't move that person into your already acquired house, right?
Mhm.
And let's say both of you live somewhere else, so that is not a matrimonial home. And you guys divorce, like, let's say after 5 years into it. Do you still owe them any portion of your assets
Yes, it
externally from the matrimonial home?
one. In a court decision of, let me see what it was, Chisholm versus Chisholm. He had assets in a company, and he was married before, and he had his children along with him with the shareholders of the company. He got married, and when he got married, he asked his wife to give up her career, and he then had her advise him as how to, like, the bill of his business. And she was assisting him in building up his business. He got quite a bit of income from it. Then he decided to let her go. And he didn't want to give her anything. And the court ruled that he couldn't do that. Once she'd given up her career for him, she was there straight through acting as a wife. She helped him build his business, and he had to pay her. And she was not even well at that time. And the court said he had to pay.
Yeah, and I agree with the court.
Here comes elsewhere now. He
has arrived.
I almost think you have no choice, Mr.
I was
Johnson.
just listening, right? You know, over how property rights for women develop. At one stage, women were seen as chattel themselves, and they could not own property. All of their property were owned through their husbands, and so even sometimes when in the old primogeniture rule, when the husband died, it went to the eldest son.
Right,
And
yeah.
so the law developed in a way with I think the Married Women's Property Act and a number of acts to give women an interest, because it doesn't say a matrimonial house. It says a matrimonial home. And a lady does so much to make that entity a home. And so, you know, sometimes the courts give value to what is a tangible contribution in terms of the lady being there. They may say cooking and cleaning is a lot. And a number of other things. You know, and sometimes you find it with the support of children. When I'm gonna go to practice, I have to support my children. I have to go back and work. And so I'm opening my firm. But one of the things I had to say to men, listen, you're not in that house. Let's say a single lady, when that single lady is nurturing that child, helping that child with the homework, being the security guard in the night, in the middle of the night, when the child gets up and sniffle her nose. So what's $350 a week? You can't do that. And so it is with a married woman. There are a lot of things that they go, and guess what? Sometimes the gentleman cannot qualify for these homes without the signature or the contribution of the woman. And so in small societies like ours, when a union breaks up, then you see problems. The man either can't afford it or the woman can't afford it, or they find a significant other. But that initial investment could not be had, even though this gentleman says she's left for 10 years. Well, she's left her interest for you to enjoy. Because I don't know whether or not she signed as a part of the mortgage, but for some time she was there supporting you. And so you can't do that for something.
All the women gone quiet.
I agree with what he's saying. I waiting for him to finish.
Yeah, we were listening.
Oh.
I agree. Because they can't do it.
So back in the day when women were considered chattel, that would have been back in the times where when a woman went to marry, her father would give her a dowry, right? And her property would then become her husband's. But what would happen if the husband died to her property that she came into the marriage with? Would she retain that, or would that just dissipate into the, to the oldest son?
In all of this.
Dowry right evolved to the wife, especially you're getting ready to sell and all that. But we've abolished that. But
Mhm.
we
No,
still see technically how we view things when we come to, and this is what's shocking sometimes to I wouldn't say men, but this is what is shocking, because you still view it as a woman not having rights in property, where the laws have moved forward in other jurisdictions. It hasn't progressed as fast where we have it in writing here in the Bahamas. But culturally, we still see the contributions that women make as being null and void, when in fact, you see it sometimes when the marriage, or let's say hypothetically, I see it. Let me say I see it when a
Mhm.
man has constructed a building, a business, a big home, children went to college, and all of a sudden this idiot meets a 25-year-old and leaves his wife for 25 years. The business take a nosedive, the home look break up, and everything falls down. So you get an idea then who was really carrying that business and who brought stability to them. And you see it all the time.
It's the women.
And the men, you can't leave the man out.
When I was speaking about dowry, though, I didn't mean it in today's terms. I meant it in, back when, from like English law, when young women were married off, their fathers would have to pay the husband whatever plots of land or sheep or whatever it was that they were.
Oh, you're talking about bride
living.
price.
Pardon?
You're talking about bride price?
I never heard that term before, but I know they would say, well, they have to pay the dowry. Like, for instance, when Henry VIII was, when Catherine of Aragon was getting married to Prince Arthur, her father had to pay a dowry for her in order for them to be married. So she came with riches and wealth into the marriage and into the family, which is what used to happen for most people, but on a lower scale, right? I mean, it depended on how rich your family was and, what the negotiation was, because it was really a negotiation of contract between the two families. I mean, can you imagine, Mrs. Archer, having your father having to pay some guy to marry you? It's, but what I was wondering was that did that wealth then, if let's say the husband died, would her wealth revert back to her that originally came from her father or her side of the family? Would it revert back to her in case she needed to marry again or something? Or did that just get lost in the mix?
I don't think so either.
Because all of today's laws are still stemming from some of those old laws.
They've been trying for years now to amend the Matrimonial Causes Act and to bring it into the 21st century. But there's been, even in terms of what qualifies for a divorce or for common law marriages, what is a deficit to women? A woman meets a man, and for all intents and purposes, she lives with him and everything a part of the class.
No, go ahead.
25, 30 years, and then she dies. And then the children say, well, you wasn't daddy has a wife. And she goes without nothing. She goes with nothing. So, yes, a lot of what, insofar as we have not amended our laws and brought them into the 21st century, I remember Justice Hall would always say that. As a matter of fact, he had the saying where he says the law is an ass. And why he said that, it can sometimes be the ass. He explains this case where this daughter did everything for the dad while he lived, but under the old law, she was not the eldest son. So when the man died, everything went to this witless boy who never did nothing for the father. But here you had the other children along with this daughter who was taking care of the father. So even in circumstances where we find ourselves, insofar as the law hasn't moved to recognize common law marriages or other forms of avenues for divorce, they're sometimes handicapped, but they've tried to find ways as to how to benefit within the bounds of the law, women who would have contributed so much. But for instance, I'll tell you something personally. You may call us, or if you're coming to see one of my daughters, get to write me a letter and let me know what your intentions are. And from those intentions, I got to see how you're going to take care of them or help.
Oh, but my son said, write letter. He said that's old fashioned, never doing it. See, he's not doing that. Mhm. Yeah, it's
Part
But a
of the
lot-
reason, part of the reason I think in those days it was necessary and desired was for you to put in writing your intentions, because even an engagement is a legal contract that you could be liable to, to if you break it. And people don't realize that today, that a lot of people think, oh, nice, he asked me to marry him and he gave me a ring. Well, persons don't realize that they could be prosecuted in a court of law for breaking that contract, in the wrong way. So that those letters in writing that, I'm asking for this person's hand in marriage and that this is my intention, blah, blah, blah. That was in effect a legally binding contract, so to speak, with an intent.
Mhm, mhm.
And you could be prosecuted for breach of contract. I think that law is still in effect today, except nobody ever enforces it.
What do you mean? Breach of contract?
Yeah, with
For marriage?
regards to that.
I don't know. Only else would one doing that.
So,
And then
That's
there's
the-
also the law in
or
certain
something.
places with this separation. I forgot the exact terminology for it, but anyway, separation of affection, I think that it's called.
Separation of affection for what? For
Yeah,
divorce?
there was a case in the United States where there was a man that was married to his wife of many years, and then he met, like Mr. Johnson said, this little young whoever, 25-year-old, and decided that he wanted to divorce his wife and get married to this younger woman. And the wife had found out that in the jurisdiction where they lived, there was a law in place that was an old law, but still on the books, that spoke to separation of affection. So which in effect, it means that if someone comes in and causes the person that you're with, that you're married to no longer want to be with you, and you then sever the contract of marriage with that person, they have the right to take you to court and take legal action, which she did. And the law was on the books and it was still in effect. She did it and she actually won.
Which state was she in?
I can't remember, but I'll look it up. But I thought it was very interesting when I saw it. It was all over the news.
Oh, okay. I see something here as you were talking. I looked it up. It says, the common law tort is abolished in several jurisdictions. In fact, only a few states in the US still allow alienation of affection lawsuits. Hawaii, Illinois, Mississippi, New Mexico, North Carolina, South Dakota, and Utah. But elsewhere, our marriage laws are just so archaic. The process people have to go through for divorce, they just prefer just to live separated. It's just too much. I just read a case. I talking about
do you think it's because the courts try to give parties enough time to sort of think it over, see if they could work it out? Maybe if, if it was something that was traumatizing to them, that they would calm down and get over it at some point, in the hopes that, they will come back together, especially in the event that they have children and it's a family unit. Is that the reason why it takes so long here?
Yes, because they trying to preserve that union of husband and wife. But in other jurisdiction, you just no fault and just go about your business.
Why is it so costly to get your name back? That's your name, though.
Why it's so costly?
Because it's supposed to be for life.
What?
Because
That's
when you
true.
get married and you take on his name, it's supposed to be for life.
Okay.
That's your
another
that's your
tip I
punishment for
give
deciding
them.
to get out of it.
No, I was gonna give them that tip. That's not a punishment, because the only thing I would have my name on is the mortgage, but other than that, all my passport or my official documents have my maiden name, because it's too expensive. And that's my name. I always plan for the future. You
Oh.
want to get divorced, but I'm just saying, in the event of, I wouldn't have to change my name. Like, all my documents would be the same.
Now that's having one foot in and one foot out.
Well, I think that you should always have plan B. And you should
But
always
there's-
have, my aunt said, you should
No,
always
no,
have first,
you have
last,
to
and security in your
wholeheartedly.
savings. In the 21st century, we just talk about all this writing and suing and asking. No, we can't be doing that. We have to
But
be
you don't have to change your name back, do you? If you got married and you put your documents in your marriage name.
We're
If you
supposed
got
to
divorced,
remarry.
you're not forced to change it, are you?
No,
you're not.
no.
But what if you want to remarry? And what if you just don't want that name on your name anymore? Like,
So if you want,
it's a lot of
when you
hassle.
remarry, then you just create, whatever moving forward with the new name.
Child, that's a lot of hassle, even with when you have a mortgage and you trying to get a new mortgage with a new man. I've seen it again. Like, they're trying to come with their new name and the conveyance and all kind of hassle. I don't want to be bothered with that. Just keep your name, and you have your marriage certificate. You can present that, if anything.
But would you left your husband like he's hanging out there? He won't appreciate that.
Oh, this 15 years. I mean, I'm not changing it. No. Because like you said, if he decide to find a 25-year-old later, at least I could just bounce right back, and I wouldn't have to be worrying about that. And I won't be crying to the court and say loss of affection. No.
Yeah, I was trying to understand, how could that actually be something that you put in court, though? I mean, at the end of the day, if he doesn't want to be with you, why did you put him in court for that?
Exactly.
No, but the law didn't speak to him, she put the girl in court. It wasn't him. The law
Okay.
spoke to the person who alienated him from his
okay.
wife.
Okay, I understand.
Because that's even letting the girl see that you so bothered. No, you're supposed to just take him to court so he could pay alimony. Like, I would not be the court suing that woman. Like, no. That's crazy.
Yeah, but it's the laws still on the books in the US.
Yeah, it's all wealthy.
And guess what? You don't even need proof of the extramarital sex.
That's something.
It says the only thing you have to prove is that the marriage entailed love between the spouses in some degree. The spousal love was alienated, and the defendant's malicious conduct contributed to or caused the loss of affection.
You could imagine that in a Bahamian court.
No.
Well, listen, But that's going to make plenty money because that'll be a lot. It'll be a lot.
That's why I thought it was so interesting when I saw it.
Mhm. Yeah, a lot of the other countries have abolished that. No, they don't have that one. Stopped in Australia, Canada. Yeah, they don't do that. All right. So the last thing to talk about is mistake. And you know, a mistake will not affect the validity of the banker-customer contract unless there is a serious mistake of fact. A mistake may be made as to the subject matter of the contract, the signing of written documents, and the identity of the parties. And where mistake is proven to have occurred, the contract is considered void. In order for a bank to recover money paid by mistake, certain conditions must be satisfied. One, the bank pays a customer's money to another person under mistake of fact, having believed the signature was genuine or having believed that a payment had not been stopped. There's no requirement to prove that the bank was negligent in paying the amount, only that it had been mistaken in doing so. Second, the bank pays without the customer's consent or authority, particularly where there are insufficient funds, believing that there are sufficient funds to cover the payment, or pays a stop check, believing no countermand is in place. And third, the bank pays a check and later attempts to recover the funds, but does not act with good speed. A bank may not be able to recover funds where A, it made a representation to the payee that it was making the payment, and the payee changed his position in good faith and to his detriment as a result of receiving payment, or B, it paid another bank as a collecting bank for the payee, and the payee has withdrawn the funds. The paying bank can only collect from the payee, not the collecting bank. Where the paying bank is unable to succeed in recovering the paid funds due to a mistake of fact, it may be able to exercise and enforce its proprietary right to trace the funds. A customer is also entitled to reclaim monies paid under a mistake of fact. So where a bank has mistakenly credited a customer's account, it may redebit the account or reclaim any funds which the customer has withdrawn from the account. However, the bank may be stopped from recovering the funds if the customer changes his position in good faith as a result of the credits mistakenly being made by the bank. So that means, like, if you are expecting funds, a certain amount of funds, and then you look on your account and you see the funds are there, and then you take it off and you do whatever it was you had assigned for those funds, the bank cannot come back later. No, it made a mistake, but you know that you were expecting this amount of money and you use that your position has changed. And because your position has changed and you were expecting these funds, the bank cannot get it back. Misrepresentation. Misrepresentation is a false statement of material fact made by a party to a contract or its agent, which induces the other party to enter into the contract. So it could be an innocent misrepresentation, a negligent one, or fraudulent. And you notice most of the staff when you go into the bank, in support, business support, they normally refer matters, and they always ask the student, why do you do that? So they don't want to make a misstatement. They prefer someone above them do it. So innocent is just a false statement made by a person who had reasonable grounds to believe that it was true when he made it and at the time when the contract was made. Negligent is a false statement made by a person who had no reasonable grounds for believing the statement to be true. And of course, fraudulent is a false statement by a person who knew it to be false or believed it to be false and who recklessly did not care whether it was true or false. The parties to the banker customer contract may rescind the contract where any of the misrepresentations, whether it's type 1, 2, or 3, innocent, negligent, or fraudulent, exists, and damages are available for fraudulent misrepresentation under the tort of deceit. And negligence is a tort, and where there is an omission to do something which one has a duty of care or obligation to do but fails to do. In order to prove negligence, the defendant must have owed a duty of care to the plaintiff. The defendant must have breached that duty to the standard of a reasonable man, and the plaintiff must have suffered some loss or damage as a result of the defendant's breach of duty. Banks must be careful to avoid negligence by making negligent misstatements. And then after that, we have the duties and liabilities and rights under the Homeowners Protection Act. And most of these we've gone through already. I want us to now look at my good case that I found. Junkanoo Estates and others versus UBS. Now, who read the blog? The blog is written by the second and third appellants, Yuri and Irina. And this matter was in the court for years. Anyone read the blog? Where the second and the third appellant wrote out their views on the Bahamas as being a fraudulent center. Tony, did you read it?
No, ma'am.
What?
I'm not gonna lie to you. No, I got this today.
Oh, yeah. Okay.
Yeah,
Brianna,
I got this today while I was at work. So I printed it off and I said that we was going to discuss it in class tonight because I got
Yeah.
it this afternoon.
so let's look at these foreigners, because these foreigners love to buy land in the Bahamas. They love these investments, but this couple went all over the world. And they purchased through this company called Junkanoo. So it says here, UBS carried on banking and investment business at least until or about 19th of March 2015, and when it went into voluntary liquidation. So in July,
Voluntary liquidation was actually, they actually gave up their company.
UBS,
Yeah.
yeah, they went into voluntary liquidation.
Okay.
Don't forget now, they had more than one entity here.
Mm.
They have a group of companies. So let's go July 2012. UBS, what they're claiming now, the UBS made deliberate false statements which invited or induced them to enter an investment agreement in order to fund the investment business, which would be carried out exclusively through trading facilities of UBS, UBS AG, or UBS Financial Services, using UBS electronic trading platform with instant execution of trading orders. In August 2012, UBS, in a conspiracy to defraud, offered a loan for a period of 5 years to Mrs. Starostenko for the main purpose of an investment business under the investment agreement. Now, I don't understand why she called that a conspiracy to defraud. They got a loan. On August the 24th, Junkanoo, their company, had been induced to enter into a mortgage for a monthly loan for the purposes of the investment business for 5 years. This is what they published to the whole world. UBS provided a credit facility at 1.4 million to Junkanoo on terms that at least half of the facility would be available for investment in US securities. The loan was secured through a mortgage on the said property, and the mortgage was a part of transactional arrangements under the said investment agreement. UBS carried on the trust business for Junkanoo, where money on the investment account was held by the bank on trust for purposes of the investment business. UBS carried out or purported to carry out sales or purchases of securities on behalf of Junkanoo from or about June 2013 to September 2013. UBS failed to perform their obligation imposed under the investment agreement. On October 3rd, 2014, a money lending action to recover loans secured by the mortgage was begun by UBS in the Supreme Court. And a month later, on November, the respondent applied for summary judgment. UBS, without reasonable and probable cause, instigated legal proceedings where the unsubstantiated allegations against the appellants were motivated by malice, employing improper practices, and equating persecution to intimidating and terrorizing. On November 2014, Mrs. Starostenko filed a defense and a counterclaim for unliquidated damages. On November the 5th, 2014, UBS applied for summary judgment, which came before Honorable Justice Milton Evans, who granted to UBS an order for possession in default of payment of $920,000. On the 24th of February, 3 days later, a decision by the Privy Council was announced, and on the 3rd of April, 2017, the Privy Council delivered its judgment on the case. So the two stars, I call them stars instead of saying Staroskenko, followed the procedures based on their lordship's opinion, while the order for possession was not enforced by agreement of UBS with the Privy Council. In November 2017, in an action, the two gentlemen filed with the Supreme Court a new statement of claim that amounted to about 1.9 million plus damages, or in the alternative, $6 million, explained by the extraordinary growth of financial markets. November 2017, UBS filed a defense in which allegations of fact made in the statement of claim traverse in a manner that amounts to a general denial, not containing any statements of fact, which leads to a view that at the outcome of the proceedings, the two gentlemen may be bound to recover against the bank, which does not exist anymore, much more than it sought to recover against them by the order for possession in default of payment of $920,000. On December 2017, Justice Milton Evans granted the appellants leave to appeal to the Court of Appeal against the order for possession, but refused to stay pending appeal on the ground of hearsay evidence, which was contrary to the weight of the evidence filed with the court. In February 2018, the gentleman filed with the Court of Appeal a notice of appeal and an application for a stay of the order for possession made on the 23rd of March 2015. In February 2018, a single judge of the Court of Appeal, the Honorable Sir Michael Barnett, in his judgment, granted the extension of time, making the notice of appeal competent, but refused a stay. On the same day, February 2018, in the afternoon, the gentleman filed an application for leave to appeal to the Privy Council from the part of the judgment of the Honorable Sir Michael Barnett, refusing a stay, and gave a notice to Mr. Jack Davis, the Deputy Provost Marshal, refusing his license to enter the property. On the 12th of February 2018, the application for leave to appeal to the Privy Council have been heard by the panel of the Court of Appeal, in which sat also the Honorable Sir Michael Barnett. The court acceded an oral application by the gentleman supported by a skeleton arguments and ordered that the Honorable Sir Michael Barnett recuse himself. The Court of Appeal found that the application for leave to appeal to the Privy Council was premature, and the appellants may apply to the panel of the Court of Appeal against the order of Sir Michael Barnett. So on the 15th of February, the gentleman filed a notice of motion of application to the panel of the court, including an application for stay of the order for possession, praying to Mrs. Sharada Ferguson, the registrar of the Court of Appeal, for an urgent hearing. On the same day, they were served with a writ of possession by Mr. Jack Davis, who made it clear that on the 23rd of February 2018, he would expel them with their children from their house by the police force. On the 27th of February 2018, the execution took place in the form of an illegal distress, where illegality occurred for the bailiff with forcible entry, and where the police powers of entry and seizure were used unfairly, irresponsibly, without respect for the gentleman and 5 minors being actually physically expulsed by force from the premises with unlawful discrimination, harassment, and victimization, and in the violation of human rights of children under the United Nations Convention on the Rights of the Child, including physical and oral assaults against one of them who is a minor, and key principles of the Human Rights Convention, right to privacy and respect for personal property. The Starostensko with their children were forced out of their dwelling homes of 10 years under an order to pick only things for one night, and a promise on the part of UBS to be able to come back the next day and collect necessities for living and studies of children. At the time when the eviction was taking place, Mr. Maurice Arthur, the listing officer of the Court of Appeal, informed Mrs. Starostensko at the court building that the court is not going to hear the notice of motion filed on February 18th, containing an application to the panel of the court against the order of the Honorable Sir Michael Barnett and for a stay of execution, without giving any reason for this decision, which was contrary to what was agreed for the hearing. The execution amounted in law to a wrongful and unlawful eviction by trespassers, actuated by malice and orchestrated by UBS and its agents in a conspiracy. And on the 1st of March 2018, they filed with the Supreme Court a writ of summons for trespass and conspiracy against UBS's attorneys, security, commander, bailiff, and locksmith. The police force have so far ignored a report regarding acts of violence against children committed by bailiff and locksmith during the course of the eviction. And the Commissioner of Police didn't answer the letters that they wrote. The promise of re-entry and access to the premises was violated by UBS or its attorneys. And they said that they still cannot access their house to collect their belongings and school supplies. And it says that UBS or its attorneys acting maliciously required them to sign a deed of release in exchange for one access to the property. In March 2018, they sent a letter to the attorneys for UBS blaming them and the liquidator for UBS that they are the true co-conspirators who entered into an agreement to defraud professional law enforcers and public authorities to corrupt public morals and to outrage public decency, for saying that unjust or unfair decisions of public officials would or might result, and in fact resulted in the unlawful eviction by trespassers. And the said allegations have not been refuted by none persons which were blamed by the said letter. So after the eviction, they applied in writing and sought by phone call from the Court of Appeal for an urgent hearing of their substantial appeal and the reconsideration of the refusal to hear their application, including an application against the order of Sir Michael Barnett. So in March 2018, UBS wrongfully filed a notice for taxation of UBS bill of costs, pursuant to the ruling of Sir Michael Barnett. In April 2018, they filed with the registrar and the deputy registrar of the Court of Appeal an objection against the taxation of UBS court. And of course, after that, they sent in a bunch of documents. They draw attention of whom it may concern that UBS or its agents have not filed any evidence at all in any proceedings to oppose their allegations of perjuries, fraudulent conduct, malice against UBS or its agent by means of affidavits and statements in open court, and more particularly, and they listed the affidavits that they submitted. On April 2018, the deputy registrar issued a summons to the parties to settle the record containing requirements for payment of fees for due prosecution of appeal and for costs of the respondent. April 2018, UBS issued blackmail that if we will not sign their deed of release, they will throw our belongings and cats out of the house. And our client will consider that you have abandoned your personal possessions, and they will accept no liability for how the storage facility treats the same thereafter. And on the 17th of April 2018, UBS issued new threat that if we will not pay the cost awarded to them by the Court of Appeal for the hearing in 2015 and for the cost not yet even taxed, they make a new application to the Court of Appeal in order to have all the proceedings in our case be stayed. And this was circulated worldwide. Now, so after going through all of that and going to the Privy Council, what was decided in 2018 by the Court of Appeal? Yeah, their husband and wife, Yuri and Iranian. I don't know why they put MESSRS, but anyhow. What do you think the court decided? Because they're claiming that UBS didn't provide them with the electronic platform in order for them to make their investment. And so they're claiming that sum of money, that 1.9 million, saying that UBS breached their contract and that they defrauded them because they signed an investment agreement knowing that they didn't have the equipment in place in order for them to actually trade. Bearing in mind that they have defaulted on the mortgage.
Okay, Ms. Archer, I'm sort of lost here.
You
Okay.
are.
Yeah, okay, this is what I'm gathering,
Mhm.
that they went into an investment agreement with this company
And
But
got a
they-
mortgage.
and got a mortgage for their home. But the investment was a scam from the beginning?
That's what they claim.
Okay. Okay. They claimed that it was a scam from the beginning. Okay, so they actually went to court to prove that this was a scam. But at the same time, they defaulted on their mortgage.
Yes.
So they wasn't paying their mortgage. Through all of this, going back and forth, making affidavits, going to court, the court agreed that what they wasn't deported and that they had to move out of their house because they wasn't paying their mortgage.
Mhm. See, they claim that they couldn't pay their mortgage because
They
UBS,
didn't get the returns on their investment.
yeah, they didn't give them the electronic platform for them to invest their money.
To invest their money.
and- Right, so they could get money from the investment to pay the loan.
To pay the loan. Okay.
Seems to be two separate situations going on. And when a financial institution gives a mortgage, they give a mortgage based on income that you have and that you have steadily coming in, on the basis of, predicting what you have coming in. And that's usually from something that's constant and something that's concrete. An investment is not something that is necessarily constant or concrete.
Yeah.
Because you could invest your money in the stock market and you can make, millions, or you can invest and all of a sudden the stock market drops and you lose millions.
Lose everything.
So I can't see them granting a mortgage based on an investment that hasn't yet been actually completed.
Yeah, because I don't understand how UBS did that, because they gave them a loan, right, of 1.4 million. And they told them that half of it, they could use it for investment. So how did they qualify for the loan? How are they going to repay the loan back? It can't be from the investment because there's a risk involved there. They're going to put all the money on one item and lose it all. So how is UBS going to be repaid?
Well, is it possible that the house was valued at enough where even if they didn't repay even if the investment didn't go through or they didn't, repay, the bank probably felt they had enough collateral to cover it no matter what?
Yeah, probably. It didn't say what was the value of the home, but most likely, if they loan them 1.4, the house probably is worth how much? 3? Or 3 million. And so they said that because when they defaulted, but they said that they had a defense, and they said that their defense was UBS breached the contract.
Yes, yeah.
And so then they did a cross claim. And that's what they've been all of these years, where they've been back and forth paddling like ping pong.
Yeah. They
Saying
were
that,
playing tit for tat.
yes,
Mhm.
they wanted the court to make a decision on UBS and their fraudulent activity. And then based on that, according to them, they would have won and they'd been able to pay the mortgage and not lose their home.
But the thing is, if they didn't trade, right? If they had intentions of trading and making an investment, but then they didn't do it because the platform wasn't available, that means they should have still had that money that they hadn't used as yet to pay some portion of that mortgage.
No, they already spent that.
And that's exactly what happened there. That's why they couldn't pay that mortgage.
But look at it like this. They came here to buy this house, okay? And this is what they typically do. They come in to buy the house. They qualify for the house, for the mortgage. Now, they got more than they needed because they took the house and based on the 1.4, 700,000 was for them to invest. And they used the house as collateral. And then they want to use that more or less say by chance to invest and pay the mortgage. Their scheme, what they have just depicted in this whole thing is how the funds were to be utilized on these electronic platform, and that's the reason why they couldn't pay the mortgage. It's fraud. They're the ones perpetuating the fraud, How you could get a mortgage and you're going to pay it from speculation? And then turn around now, you're saying the mortgage isn't paid because you didn't have the electronic platform. And so now you want to sue UBS for the monies that you would have earned had you had the platform and you had placed an investment in certain stocks. How is that plausible?
But there's no guarantee. Making an investment is like playing in a dice game,
And there's no guarantee that if it is stock A, B, C, and D, at that time, you would have chosen A, B, C, or D, or how much you would have invested. So they wanted to sue UBS for something that they did not do. So from paragraph 11, the court sets out this contract between the parties, between them and UBS. And he said that it's exactly what you said. He said there are two different matters. What they're looking for is damages. And that has nothing to do with the mortgage. And it cannot fetter the mortgagee's right for possession. He says in paragraph 18, he says in Major versus Citibank, Justice Longley said, subject to the caveat that the mortgagee's right to possession is also subject to statute. I would agree with the opinion expressed by Judge Harmon, as representing the law with respect to the right of mortgagee to possession. And the reason he has that right is that on execution of the mortgage, which is achieved by conveyance of the legal estate, he becomes the owner of the legal in estate in the property, which vests in him on execution. Accordingly, as an incident of that legal title, he is entitled to possession. There is an action for possession. Inter alia, the defendant sought to defray the plaintiff's right to possession on the grounds that there were cross claims that exceeded the amount which the plaintiff contended was outstanding on the mortgage. The court held that a mortgagee's right to possession could not be defeated in these circumstances because the mortgagee had, as an incident of his estate in the land, a right to possession of the mortgage property. And cross claims could not be unilaterally appropriated in discharge of the mortgage debt. In the case of Ganpat Singh, in the Court of Appeal case, he said the position at law is that where under a legal mortgage, being an installment mortgage, the whole money becomes payable by reason of the default of the mortgagor. And the legal mortgagee is entitled to possession of the mortgage property. The court has no jurisdiction to refuse to make an order, but this does not exclude a power to direct an adjournment for a short time to enable the mortgagor to pay off the mortgage in full or otherwise satisfy the mortgagee if there is a reasonable prospect that the mortgagor being able to do so. So they were not offering to pay the outstanding amount. They actually put forward a cross claim because they wanted to sue the bank for much more.
But it wasn't the bank's fault.
No, the whole setup, I don't think they understood that when they explained how they intended to pay the mortgage payments, that whole arrangement is fraudulent.
Fraudulent.
That is fraudulent because you borrowed money. Yes, you gave your property, but they had no intention of giving up their home.
No.
They got 1.4 million, and they wanted 700,000 to gamble with.
Yes.
And then when they would not have made the proceeds that they were looking for, then they intended to sue. They had already foreseen what they were going to do.
Yes. But it didn't work out in their favor.
No, it didn't work out in their favor. And so that's why they went all over the internet with this blog saying that the Bahamas is a fraudulent jurisdiction.
Trying to badmouth our country when y'all came here with
They did.
fraudulent tendencies.
They really did. So the judge said that I am satisfied that whatever relief the appellant seek must be found elsewhere than from the respondent. In the premises, I would answer the question posed in the affirmative, but with a caveat. The caveat is that the applicant would have to demonstrate a strong balance of probability case that the court should interfere. Nevertheless, my positive finding is of no avail to the appellants, as there has been no basis shown for this court to interfere with the decision made by Judge Evans. And he said they need to seek damages. And they could go to the court below. But in my view, this whole arrangement from the very beginning is fraud. You expect to get 700,000, don't pay back on your loan of 1.4 million on a chance.
Do you think they really explained that to UBS? Or maybe could it be that they presented possibility of income through some other means? Because clearly they didn't just sort of appear out of the middle of nowhere.
No.
They must have had income from wherever it was that they were living beforehand. And they probably used that to qualify themselves for the loan. The extra 700,000 that they were going to maybe, I don't know, improve the home or, do certain things that might have made sense to the bank at the time. But, of course, the bank, once they would have signed off and given them the money, they weren't probably even paying too much attention as to what was actually being done. And especially if the home was valued, in some cases, persons purchase a home, but the value is much, much more. Like they might have gotten a really, really good deal on the home because maybe the person selling the home to them was desperate to sell and just, wanted to be done. So they might have gotten a home for, a lot less than what it was actually valued at on the appraisal. So the bank wouldn't have had any issue giving them the money, especially if they were able to substantiate in some means of income at some point that would have been able to help them to repay it.
And if you look at this arrangement, most likely the money that they purported to actually have, they may have borrowed that too. In order to qualify, because it wasn't just the home, because you have to show that you have some kind of income that's going to be able to pay this mortgage.
Mm-hmm.
And they're able to doctor any document. And just think that the extent that they went to globally to speak about the Bahamas, knowing that what they did was fraudulent. It's just unbelievable.
But that's what con artists do, though.
Yes. That's what they do. They were represented by, who represented them? Yeah.
What do you think about the portion of it where they were extracted from the home?
I don't know. Elsewhere, that's unbelievable. I don't understand when they say they were extracted, they were only allowed to take something for the night. I don't know.
But bear in mind, they would have had a court order of eviction for them to vacate the premises really long enough in advance for them to remove all of their belongings.
Mm-hmm.
And to be gone and to be peaceable about doing so. But clearly they ignored that and they stayed, and they were probably belligerent when,
Well, obviously, listen, once you read the blog, you could see they stood their ground. They probably said they're not moving.
I don't know. We seem to be very lenient with eviction here because in the US, they come and they remove your goods and put them out on the sidewalk. And that's one day after basically they tell you that you're evicted. The day of eviction, the sheriff will come And they will literally physically take your things out of the house with you standing right there and put them on the sidewalk.
Hmm.
And if someone comes along and removes something, steals something, they're not liable because they give you notice that you have a certain amount of time to vacate, and they don't even play around with that.
But I want you to notice the dates of this thing. The legal mortgage was executed on the 25th of October, 1985. In February 1988, the bank issued proceedings to seek possession of the mortgage property 3 years later. And this matter is not resolved until 2018. 2018? No, 2020. You see how many years that is?
So, Ms. Archer, what is wrong with this picture? From 1985, they were they knew that they were in foreclosure. 1988, the bank took steps to, get
Yeah.
the court ruling. So that means all those years in between, up until 2018, they were living in the house for free.
Yes. And just sending out blogs all over the place. You see how many years?
And they had the nerve to say the bank owed them damages. They really owed a lot of damages themselves. That's a
Mm-mm.
lot. Of money.
Yep.
That's a whole lifetime. For some people.
Yep. Mm-hmm.
That's 33 years
It's a long
it
time.
was
All-
going on.
Oh.
And during that time, the bank didn't sell the house to anybody else in the meantime,
No.
Don't seem to be.
which
No,
is unbelievable.
But don't forget that UBS went into liquidation and all.
That was another battle.
Yep.
So that means they just took a loss on that, or they were able to recoup.
They didn't
some
say.
funds.
This is the last thing, 2020, and I don't know what they did. They probably sold it. But this property should be known, Junkanoo Estates. This is the company that owned the property. There has to be a property out west called Junkanoo something. Yeah, 1.4 million. So it's a lot of money for a scam. A scam. Yeah, they stayed in this house for a very long time. Free of charge. They paid no mortgage payments. Isn't that wonderful? You think we could do that?
How does that happen?
No, we wouldn't be able to do that. The bank will be right on top of you. In
All
two-
they did
two
was-
shakes of a lamb's tail.
But all they did was they just tied this up in court,
In court, yeah.
over and over again. They just keep appealing and filing this, appealing and filing, and they ran that out for 30 plus years.
Only in the Bahamas.
Only in the Bahamas. They were in their 30s, they're in their they approaching 60s. If they're in their 40s, they're in their 70s. And if they were in their 50s, they ready to go.
They're ready to go, exactly.
But they've lived their life without paying a dollar.
Without paying a dollar.
Unbelievable. Unbelievable. So, like you said, only in the Bahamas. Can't happen nowhere else.
Yeah, not nowhere else.
Can't happen. Mm-mm.
3 years. Wow.
When I found the case, I had to send this to you all. I say, oh my God, what is this? How can this happen?
Wow. Hmm.
I don't know. It's unbelievable. Because the court said that the bank as a mortgagee, the legal mortgagee, they have that right in possession of the mortgage property, and it can't be defeated by a cross claim. So all of these attorneys going back and forth couldn't figure that out, wasting time.
That's what you call stall tactics.
But it worked. First
Yeah.
they fraudulent scheme, and then they just used the courts and
Mhm.
stalled time until they lived their full life free of
Yeah.
charge.
But you also have to remember that every time these lawyers go to court, they get paid.
Well, that's true too. See, also quiet now.
He disappear on us again.
He disappeared again, see? Because we talking so he gone. He's online.
Yes.
Yeah. But he's not chimed in. He waiting now. He waiting on that clue. Then he can come.
Ready to come in and finish us off.
But it's just I when I read this, I couldn't believe it. I just couldn't believe it. Because by the bank having that legal, remember from the very first class, when we spoke about the interest in land, and then we went a mortgage itself. When you go to the bank and you seek those funds, and then you give your security, that automatically, once they have that registered, that give them that legal right. They have the right of possession because they have the legal estate. I just don't understand how they spend 30 years bouncing back and forth. It's just a cunning ploy to live for free.
And they achieved that goal.
Yes, they did.
Yeah.
Mrs. Archer, I know of a case that happened several years back now. This foreigner came over, opened a business, decided at some point that they wanted to purchase a home. And there was a woman that was selling her house. Her husband had died, and they had this huge house that she felt she couldn't manage to take care of all by herself, seeing that her husband had died, and she decided she'd sell the house and take the money and, get something smaller and just kind of live comfortably. And I think she was selling her house for something like $400,000 or something like that. Or she might have wanted more, and somehow this person got her to agree to go down in the price. So it ended up being $400,000. And after agreeing to accept the sale, for the $400,000, the buyer further went and said, hey, in order for me to not have too many fees to pay, what if we just put on the conveyance $250,000 and I give you the rest in cash? I give you the rest on the side, not literally in cash, but in some kind of instrument, right? So foolishly, the seller agreed, and they did the conveyance and everything. This person went to the bank, borrowed the monies to purchase the home. Of course, the $250,000 was exchanged to the lawyers, and the conveyances were done. And then, of course, the lady was like, okay, so can I have the rest of the money now that, we agreed that we would do separately? And so he promptly told her, no, well, what's on the conveyance is all I'm going to pay. So anyways, I guess eventually karma is something else that happens because, you know, he ended up defaulting on the mortgage for the home. And the bank, of course, went after him and his family trying to, you know, get them to either pay or to leave. So eventually they got a eviction through the courts for him. And that took years. So for several years, he and his family were living in the house free of charge as it went back and forth. And he kept on going back to them and saying, you know, promising to make an arrangement to pay and all these different things. And eventually he skipped town, him and his family. And his wife was sick. His wife got sick afterwards with cancer and everything. And like all sorts of stuff happened. But I'm just saying, you know, karma. But
Yeah.
at the end of the day, he defrauded, he defrauded her. He got this fabulous home for little or nothing. Okay, huge, huge, huge home on a huge, huge spread of property. I mean, that house must have been on like 3 or 4 lots. And he lived in that home basically for free because he did not pay the mortgage. And then he didn't, shortly after he got the mortgage, he defaulted. So it wasn't even like he invested a good deal of money in, you know, repaying the principal and interest or anything.
That's exactly what these say. It's just a
And
scheme.
he knew how to work it. And honestly, like, and eventually he just skipped and left. When he was good and ready, he just skipped out and he left, and he didn't come back. But he didn't care because as far as he's concerned, he got out of it what he wanted.
Yeah. But I thought this was a good one. I've never read it. Didn't think it was possible. Free for 30-something years. That is totally unbelievable. Totally unbelievable. Yeah. So you could sit down, you could actually read the case. Again, it all comes back to the same thing. The courts will not fetter the bank's, the mortgagee's right to possession. You got to come up with a good reason why. But he surely stalled for 30-something years going back and forth. And it worked for him.
Yes, it did.
It worked for him. All right, so next week we're gonna do on Monday, understanding the mortgage process.
We have an exam Wednesday in this option.
Wednesday, which Wednesday?
The 29th. It's a practical examination of legal documents. Or is
No,
that an exam? Oh,
no,
okay.
no.
Okay.
One exam at the end.
Oh, okay.
Aren't you lucky?
Not really. That's more.
Aren't you lucky? No. Let's understand mortgage. You know what could be good for those who are working in the bank and the mortgage co-op? If you could bring your interest rates,
Oh, okay.
that would be,
Which is really nothing right now.
yeah. And then what
How
else?
do you all feel about Royal Bank and that new interest? No interest. How? How are they allowed to get
Hold
away
on. That better right? And everybody by word of mouth, you know, Bahamians. Oh, close my account. So I saw Royal Bank staff. So I said, everybody's saying they're closing the account. She said, closing what account? So not a single person closed an account for the day. This was the one in Palmdale. I say all this noise they made. She said, well, they don't even have enough to close no account. So I don't know what they're talking about.
I bank with Royal Bank, and honestly, I feel like they are the worst. It's just that I just don't have the time to like walk down to go and close out their account. And what bank is offering more except the credit union? I mean, the bank now is not anything which you use to save. It's just used for transactions. So
I
I
think
mean, with them saying
we
that they
hardly
were
offered
putting on
anything.
paper,
Mhm.
the fees that they taken off, so I mean, to keep your money there is more than what they ever put on anyway.
True.
Yeah,
Yeah, that's because the banks are liquid.
I've been trying to call Royal Bank must be for a month now to get a new debit card. It's like I just transfer the money.
Why you
to
calling them?
Huh?
Why you calling them? Just go to your branch.
Yeah.
It's ready.
No, I misplaced it.
Oh, you need a new one. You still have to go to.
Yeah, I need a new one.
Okay, you either go to your branch or you go to the Southwest Plaza branch.
They
One
say
of the two.
they print in Canada now, so it takes a long time. My friend said she's been waiting on her credit card now for 3 months.
It expired.
No, so someone stole her wallet.
Oh, that's different. Because I know once they expire, they're ready.
Right.
Yeah, they usually are.
Yeah, they're very quick with that. But don't forget now, you have the domestic banks and you have the Canadian banks.
Right.
And there's two totally different business models. Totally different.
I feel like we should be using our Bahamian banks anyway. We should be using Commonwealth and
I feel so too.
Bank of the Bahamas. I feel that they have too much say and we need to put our money in our own
Yes.
banks and let them go where they go in. And the
I-
staff with at Royal Bank, just change them into Bahamian banks. Because
I
they
bank
have
with
too
Bank of the
much say.
Bahamas.
Yes. I
Yeah.
feel that's what we should do. We should do that with Bahamian. We just talk a lot. But
Yeah, because you find other Caribbean countries, they stick to their domestic banks.
Yes.
yes. And the
But
money.
then that also helps the country too, because at
Yeah.
least your money would stay here.
Yes.
Exactly. The fees, I rather the fees stay here with the locals than for Royal Bank to be taking all the money away.
Yeah.
But you
So
look at it, but look at it historically now. When those banks came here, they were reaping. They were repatriating millions of dollars at the end of every year, you know.
Yes.
That's what they made of us.
Exactly.
Running
And
loans every minute.
Yes.
And
exactly.
Bahamians love loans.
Top performers in the region. And
Yes.
that's why I don't understand why no government has addressed that yet. None.
Mhm.
I don't
But
understand it.
isn't the government, I think their major account is with Royal Banking.
Yeah. Mm-hmm.
Yeah. So
In violence. So, depends on the
they are deeper than we could ever imagine.
yeah.
That's right.
Don't forget the Royal Bank has been here for so long.
Yes, it has. True.
So
When did
they've
it go?
always been their bank. And then when they want to do, like when the government, quasi-government organization need to get financing, then they will go through Scotia.
They will go to Scotia.
Uh-huh. So, but that's just how our banking system is actually structured. Now you could get some comfort with the credit unions now that they come under the central bank. So that
Yeah.
means, you know, they're heavily regulated now.
Yes, we are. Just like the banks.
Yeah, just like the
Have
bank.
no leniency with us.
Yeah. What's the interest rate at the credit union?
Well, right now on our regular account is 0.50.
Oh, Jesus, that number too low.
Yeah, we struggling just like everyone else. The
You have a
most you would get,
liquidity, right?
yeah.
And no
But the
one
most interest you would get out of any account that we have would be our pension plan, which is Gold Star plan, and that gives you 3.75 at the end of the year. That's it.
Yeah. And then when the credit bureau comes, it's going to be worse.
Oh, they're here. They are
Yeah.
here, and a lot of Bahamians are so in awe. They even don't know that the government have them in a credit bureau.
What you mean it was in the papers?
Yeah, Bahamians don't read, Miss Archer.
Oh,
And you're like,
it
you already know that?
twice
Yeah, you know
said.
something too. You know your debt ratios analysis with credit unions, we used to be 60%. We are now at 45% like the banks.
Yeah, with the banks, yes.
Yeah, so now we in struggle for our survival. Because how do you bring payments from 60% BSA to 45%?
You're gonna have to do it. The
That's
same,
what
the,
we're struggling with right now.
Alone.
right, the same way the governor has been saying for years, please start getting a savings, and they don't listen. Christmas come, they need furniture, new car,
Miss
new this,
Oh,
new
Archer,
that.
yeah,
but Miss, no, Miss
and they
Archer,
still doing that, Ms.
realistically,
Archer.
no, realistically, y'all, I have to say, we can't look at it like that. I work
Okay.
with a different target market of clients, and it's really hard. Like the average person is not even making like $40,000. You go to Rupert Roberts, that's another mortgage. When you go to buy food, like
Hold
it's
on,
expensive
he just
to
Joanna,
live
said
there.
he could not fix the prices until 2022.
Exactly. Listen, a loaf of bread is $4. You have a family of four and you make 4 sandwiches, the loaf gone.
yellow farm, so.
Like you
But the,
cannot, flours, I don't say bacon bread. Everybody in here working, ain't nobody trying to be bacon no bread. It's expensive to live here. The light bill is high. The water bill is high. Just gas is high. Like they
So,
saying like
so,
save money, like you getting paid so much. Like
so Hannah, what do
like
you think
what?
about Grand Bahama? If Nassau is
And I'm
expensive,
from there.
okay.
Exactly.
And
It's
you see
rough.
the other day, they have where, Grand Bahama Power has received the okay to get a raise in our power bill. You can't pay power
Exactly.
bill now.
That's 2 mortgages.
Okay,
And it's like, come on, you telling people to save? What they saving? Realistically, you cannot save in this country. Like it's not for the average
true.
payment.
I agree because you know what
Not
I
for the
did?
average payment.
I had a lady last week. We're running a promotion and she works at KFC. And she's been there for 20 years.
they pay well.
And she makes $300 a
What?
week. Yes.
What is she,
Yeah.
mop the floor?
She's a manager.
Oh,
You
She's a
sure?
manager. I'm telling you, it was on her job letter. You have KFC workers who still making minimum wage and been there for like 17 and 15 years. Yes,
Really?
yes. You have security officers that come to the credit union, been on the job 5 and 6 years and only making $980 a month for 40-hour weeks.
and that's why we have a brain drain because nobody wants to stay here. You can imagine going off to school, getting your education, and coming back here, and they want to just pay $40,000,
Yes.
and then Rupert charging you. You spending at least
You-
to eat properly.
Why is she picking on my boy?
Because I love Rupert, right? And my friend was telling me like, okay, well, I guess you can't have fresh fruits and vegetables. Like, why should I can't even I don't know what it is for a family of 4 who lives on minimum wage, how they're doing it.
Mhm.
I do not know. I do
Girl,
not know. And that's
you know,
why
you have to
yeah.
now, when you go in the food store, you have to pick your necessities. You know, before you could have shopped, but now you have to pick necessities. You have to pick what you really, 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 really need.
Milk is $10.
Okay,
That's even if you want to make cereal, even the
okay,
generic milk is $10.
okay.
Come
Don't buy
on.
don't buy a gallon of orange juice.
Well,
That's-
actually, it's costing you $20 to have cereal because the cereal itself is going to cost you almost $10.
Exactly.
So
Mhm.
cereal and milk together, that's a whole lot
That's
to pay
$20.
for. But you know what the problem is too here? It's not just that prices are high. We don't get value for money and quality for money because when you go into the food
Exactly.
store, the prices are very high. But look at the rotten fruits and vegetables that they have on the shelves in certain areas. Let me put it like
And
that, because
it's gonna
maybe in
get
certain
worse.
other areas, they have the top quality produce and
No,
all the
all
different
scam.
choices of brands and different things. But I
Yeah.
noticed in certain areas, they
Mhm.
seem like they don't care. Sometimes they don't even clean the shelving off. And I pointed out once to a worker, do you see the mold on the shelving where you have the broccoli laying up and, you know, the asparagus and whatever? Okay, literally there were rotting stuff on the shelving.
Yeah,
And you don't mind to pay for something that's you know of value to you and you're getting, you know, worth for your money, but to have to pay for this inferior food that is, you know, already no good by the time you get it home out of your car, it's not okay.
yeah.
When the
But
credit bureau,
we're in a really serious situation because
exactly. When they come, the credit bureau, we're gonna be finished. You thought the banks had a hard time now booking loans because you could book a loan now.
A lot of them, Hannah, don't qualify.
Proportionate salary, but what he's gonna get when you have 60% of that finance out to Fidelity or Commonwealth Bank.
And that's exactly what's happening. Once you see them have a loan at Fidelity or Common Bank, you can't even help them.
imagine on top of that now with all of these debts, all these bodies in the morgue, the people can't pay to bury the people. It's
Yeah.
like, yeah. I see a lot of people are going for insurance though. But I hope they realize that you have to have insurance for at least a year or more in order for them to pay off. So I don't know. You bankers gotta think. How you gonna make it? Food for thought.
Yeah.
Strangely enough, the foreigners seem to have all the I's dotted and T's crossed and able to come to us and get loans with lots of income and no debt.
Mm-hmm. Well, I had someone who's working in an offshore bank and she was making a comment looking at her salary and looking at what they are making. And she said the difference is just so vast. The opportunities are not here. They're getting all the opportunities. And she said she's gonna leave. She says that's not fair.
It's not, especially if we're doing the same job.
Yeah, she says not fair.
Location, they get housing allowances, they
Mhm.
get gas money. In some cases, they get a car to drive along with gas.
Yeah.
You know, they get their utilities paid for by the organization as well.
Yeah.
And
They basically all they have to pay for is food.
uh-huh. And they bring that in on the private jet.
And a lot of times they get to travel home at least once a year.
Once a year,
Yeah.
that's paid for too. Yeah. Mm-hmm. And depends on high up they are. They pay for the children's school fees too.
Yes.
Yes, at the most expensive school on the island.
Yes. So all of that. Mm-hmm. But I didn't realize that until I think it was a few months back. As I was saying, they were complaining that the prices are so high in the food stores out west. And then they all of a sudden they stopped talking about it. And I said, well, you're not talking about food anymore. No. We just go on those little small jets and they fly to the States and bring their stuff back on the jets. And the hand is waved. They say they just walk, yep.
Duty
The
free.
jets and the yachts.
Yep.
Yeah, and pay no duty while we have to pay.
Yep. While you're pushing your trolley around with no
Paying
pad on,
$4.
squeaking in the food store,
Yes.
Exactly.
paying huge sums of money, and they walking free. Uh-huh. When it's time to retire, they buy a house by the lake, by the ocean. But that's life. What can you do?
And then they resell that house for 10 times what they paid for it before they
course.
leave and move on to wherever else they're gonna go.
Mm-hmm. It's an investment. Yes,
That we don't teach in school.
true.
Yeah. Because I think if we started teaching our children from earlier, then a lot of them wouldn't be in the predicament that we are in. They don't
Yeah,
get
they,
financial counseling in school.
no, they don't. But
And
they
it's
need,
so important.
you know, they really need to start to.
Yeah, because there's no way as a young person entering a government job, customs immigration officer, you've been on the job maybe 4 years, and you have a $30,000-$40,000 debt, and you have nothing to show.
Mhm.
Yeah. And they come to you and they want you to solve the impossible. But you don't even have nothing to show, no property, no kind of investment. Do you have any shares? Coco's selling shares, Central Bank selling shares, and they're like, and they'd be lost. Like, what are you talking about? What are these things?
Even
You
all
know?
the way to University of Bahamas, they beat them. What are you talking about?
Yeah, yeah. We don't educate our people in that way.
But it's a cultural mindset kind of thing though, that we don't prioritize in the right way. The first thing that a young person does when they come out of school and they get a job is they want to buy a car that they can profile in. And
A Honda.
oftentimes the car is the price of a piece of property.
Yes,
Mhm.
yes.
Yeah, yes.
Yeah, and when they come to you and they come to you with these high-minded things, you tell them, okay, why not let's buy a property first and then buy yourself a little ride, just see if you get from there. Oh, no, you do that later. I will do that later. Okay.
I always tell them when I come across someone who, approaches us who is young, and I tell them, listen, as long as your parents are gonna allow you, stay at home and save your money.
Yes.
Okay,
Mhm.
but the first thing they want to do is move out into an apartment so that they could sleep out all night or
Yes.
bring
And
home whoever they want to bring up and down. And that's their whole reason for wanting to get out of mommy and daddy's clutches. But at the end of the day, like I told them, it's so long as you could milk that cow, because that is the only way you're going to be able to save your money. And so, and that's hoping that you will in fact save the money instead of partying and profiling. But that is your chance and your opportunity to get a foothold and at least save a down payment for a house or something. Because that should be your ultimate goal, is to eventually be able to stand on your own two feet and do well
Right.
and provide for yourself and whatever family you end up having, so that you're not a burden, to yourself or to anybody else for that matter. But they just do it all in the wrong way, like putting the cart before the horse, because before they have the house or the property, they have the heavy payments on the car. Then they go out there and they promiscuously, have a lot of children that they can't afford. So that as well, I mean, it's all about priority and being responsible and realizing that, your responsibilities have to be taken care of. And every action has a reaction there's a price to pay for all of that at the end of the day, And I think that that's something that persons don't think about. I don't know if it's necessarily the parents' faults, because sometimes you could take a horse to water, but you can't make them drink. You could pound it into their heads as much as you want to, and you may, out of 10 children, one may listen to you and the others may just go off and do the exact opposite. So I can't really say it's maybe the fault of parents, because your children, they're influenced by many things out in their environment, other friends, other people who
they also have their own minds too.
Exactly.
Yeah.
And I too, I don't agree with what y'all saying. Like I have not been telling my kids, oh, what you want to do is first buy a piece of property. No, you don't want to do that. You don't want to be in debt for 30 years, paying on a mortgage. rise in taxes and stuff. No, what you need to be doing is getting multiple streams of income from different avenues and, having different source of income. And you don't want to be stuck on a job, just collecting your salary and trying to pay your mortgage. That's not life.
Yeah.
I just think it's the culture here is just so different. And I just can't get used to it. It's just different. Because I would not want my children stuck here paying for a scare bean or Bank of the Bahamas for 30 years, talking about we just have a house. No, that's not it. That's not the life. You're not
Yeah.
gonna do it.
All right. So we've had a long class, but it was quite interesting, enjoyable. So next week we'll talk about understanding the mortgage process, and I'm sure you all will have a lot to share about the process and the charges and all the rest of it. So enjoy the rest of your week, and we will chat on Monday.
You all have a good week.
Good
And be
Okay.
safe.
Okay, thank you and good night.
Good night.
Okay.